fellow of the National Academy of Arbitrators, one of my colleagues there, in fact, a almost immediate past president of the Academy. You can read in the brochure his professional experience and what he has accomplished. What I want to tell you is a little bit about him as a person. He was born he's an Okie from Muskogee, and he was there briefly. Then moved to New Mexico, and then went to high school in Lubbock, Texas. Anybody here been to Lubbock, Texas? There's nothing there. There's nothing. Don't worry. Yeah, right. He then went to Duke for undergrad, then to Stanford. When he was born, he was a twin, and he was born 13 minutes before his brother John. For a while, that was a great thing. Now John says I'm younger. John is an immediate past president of the American Psychiatric Association. Jim, immediate past president of the National Academy of Arbitrators. Both of them very, very distinguished careers. Jim practiced law for a few years in Denver, and at age 30 was hired and began teaching at Georgetown. And I'm not going to tell you how many years he's been teaching there because he asked me not to, but just suffice it to say he's been there for a very, very long time. He is widely regarded at Georgetown Law as one of the really outstanding professors there. He's had a very, very distinguished career in legal history, which is, of course, why he's here today. He is married. His wife is a banker. They have 2 children, both of whom live in Colorado. He has 4 grandchildren, and he is the St. Thomas More Professor of Law and Legal History at Georgetown. And I think that's a really fitting and appropriate professorship for Jim, because in my years of knowing Jim also possesses courage, integrity, and erudition. So I think St. Thomas More would be happy that Jim is that professor. So without further ado, Jim Oldham.
But I don't have a hair shirt, Thomas More did. Thank you, Bob, very much, and Dean Myers, Raphael. It's a pleasure to be here, and I come to it from at first what I thought would be unrelated experiences in life. My arbitration experience, which began having come to a law teaching from a law practice that involved labor and employment law. And once I was sanitized as an academic from having been an employer representative, I began to get arbitration cases, and so I became a labor arbitrator before I ever stepped into the world of legal history. But then I had a first sabbatical that came, and I guess I was a latent Anglophile. And so I thought it would be great to spend that year in England. And I then fashioned a research proposal around a famous English Chief Justice from the second half of the 18th century, the first Lord Mansfield, who was very influential in English law, called the founder of English commercial law. Those of you've either all taken or are now taking contracts. You will be studying the joys of the Uniform Commercial Code. Lots of Mansfield decisions can be traced directly into the provisions of the Uniform Commercial Code. Mansfield was one of Carl Llewellyn's heroes, and Llewellyn was the principal author. Well, and so that was my destiny, and so I got into English legal history and got Mansfield's trial notes and ultimately transcribed and published them. And then I got interested later because Mansfield was a big supporter of arbitration, and I began to be interested in the history of arbitration, and so my 2 worlds rather much merged, and I've continued doing that work ever since. And so today I have some time to spend with you talking about oh, the shifting sands of reasons to arbitrate. And it's certainly well established, and today that has been illustrated quite graphically, that for many centuries, arbitration has been a regular, even a frequent method of dispute resolution in the Western world. And my own work, together with the help of co-authors, has been looking at archival materials from the late 17th century and then through a good deal of the 18th century, archival materials mostly from the National Archives in London. But I've done a bit of work in this country as well. Carly explained her interesting beginnings of what I think will occupy her for many years with regard to the colonial experience here. A research fellow and I have done some exploratory work there, looking at records from Maryland and records from Pennsylvania archives, both of which are very rich with regard to arbitration in the colonial period and in the early Republic period. Well, we know the fundamental attributes of arbitration. The four principal ones are cost, the economy, speed, informality, and final and binding. This is the final and binding resolution of this case that's not appealable. There are other attributes that could be identified. For example, being able to pick an arbitrator that has special qualifications, something that might enhance the possibility of a sensible resolution. I'll add a couple of more, which may be a bit surprising. One is the availability of discovery, and secondly is the capacity in arbitration for handling cases of considerable complexity. Of course, all of these attributes were not always present at the same time or in the same case. But what I want to do today is to say a bit more about how arbitration was practiced in 18th century England and a bit of comparison to the United States process. A snapshot of history here. You've had some touches of it here. Two texts on arbitration were published in England in the 17th century. One was an anonymous 93-page text entitled On the Law of Arbitration, and the second was an earlier work that was a 250-page text on arbitration by Gray's Inn barrister named John March, published first in 1648. March, and I'll quote him now, he declared that arbitraments were never more in use than now. This is 1648. And most men either have been or may be arbitrators. He said, moreover, and Raphael, I think, and Bob, I think this would be a very nice motto for the new website that you folks are working on with the National Academy, which we can talk about in the question period if we wish. But here's the motto. This is from 1648. Quote, as long as differences and contentions arise among men, which will be to the world's end, certainly the learning of arbitraments will deserve our knowledge. Unquote. Well, that was true then. It's true still today. As the author of the anonymous text from 1694 said, arbitrament is much esteemed and greatly favored in our common law to prevent the great trouble and expense of lawsuits. Okay, you've had a couple of references already to the 1698 statute. Carly called it the arbitration statute. This was a statute that was interesting. It was drafted by a name you will have heard of, John Locke, who was a member of the Board of Trade at the time, and that's why I will refer to it for shorthand as the John Locke statute. And this was an ingenious statute. The Board of Trade said to Locke, see if you can figure out a way that we can solve our disputes simply and finally with no appeal. So Locke was familiar with the practice that already existed at the time of references, as Carly expressed it, and that's the right word, a case which began as a jury trial, but in the middle of the jury trial, probably the sitting trial judge would call counsel to the table and say, look, why don't we think about sending this to arbitration for a variety of reasons? and the parties would agree, and they would then write out an agreement to arbitrate, probably dismiss the jury, or actually there was an expression that said if they were going to send it to refer it to arbitration, they would withdraw a juror. And that's symbolic, symbolic. They're not telling one of them to leave. But it meant that they put the jury trial on hold. And we're going to send this case to arbitration. And presumably that will be the end of it. If it doesn't succeed, it can come back and be concluded as a jury trial. Well, Locke understood that method, but he also understood that the key to enforcement of arbitration agreements would be the penalty that might attach for not honoring those agreements. So he thought that the threat of being arrested for contempt of court would be a strong incentive to honor arbitration agreements. So he proposed that Parliament enact a statute that endorsed the process where parties to a private arbitration agreement could pretend that they had an active lawsuit, and they would then take their arbitration agreement and file it into the book of court orders called the Rule Book, the King's Bench Rule Book. And once it was copied by a clerk into the King's Bench Rule Book, it became an official court order. And it would have a caption. It would look like it was a lawsuit that had been commenced, but it was completely fictitious. It was a pretend lawsuit. But the point was, it was a court order. And because it was a court order, if it were not honored, an attachment could issue for contempt of court. So it was a very clever device. And until recently, no one had really looked into the question of whether, or the extent to which that statute traveled over here and spread across the states of either the colonies and then stayed in effect, or in the early republic. A research fellow and I did this, and we found at least 21 statutes that are John Locke imitations in different states. And this was at a time during the early 19th century when the number of states in the Union was only 30 some odd. And so it was a very high percentage of the United States at the time that had these John Locke statutes. Okay, I would now like to start expanding the historical record a bit. And let me start with the question of economy. This traditional advantage has always been said to be important. The inexpensiveness, of course, for some types of arbitration, this has never been true. International arbitration is very expensive, very time-consuming, and very complex, and is getting more so. Lots of major commercial cases have the same characteristics as well. And even in the employment world, non-union employment arbitration now has broken away from this tradition of economy, and instead of the somewhat modest arbitrator per diems that have traditionally been used in labor arbitration, those same arbitrators who are now doing employment arbitration where there are no unions are charging healthy hourly rates. And discovery is fairly actively practiced in that context as well. Well, how different it was in the earlier era. Let me give as an example a statute that's close to home for you. This was an 1825 Missouri statute entitled Arbitration, an Act Regulating Arbitrations and References. And this was Missouri's example of the John Locke statute. And Section 7 of the Act provided, quote, that each arbitrator or referee shall be allowed for every day's attendance to the business of his appointment $1.50. And the same thing was extended to witnesses and even sheriffs who were helping with the process. Then, traveling back to 18th century England from that 19th century local example, the contrast was even greater. And I'm aided in this by some observations from a very scarce publication called Supplement to the Attorney and Agent's Table of Costs, written in 1833. I'm indebted to my co-author Henry Horwitz for this source. And the author was a man named John Palmer, and he noted that the practice of referring mercantile cases to arbitration after they had been called on for trial very much increased in the latter years of Lord Mansfield's Chief Justiceship. Mansfield was Chief Justice of the Court of King's Bench from 1756 to 1788, 32 years, a very long stretch. Palmer explained that at first this practice of reference to arbitration was attended with very little expense to the parties, for this writer himself, Palmer, remembers when a merchant or a gentleman would have felt himself degraded by an offer of payment for what was considered a voluntary act of kindness. But one of Lord Mansfield's favorite merchants, Thomas Gorman, who also was very frequently sitting on special juries and whose judgment Lord Mansfield very much respected, he was called upon for so many references to arbitration that he began to make a charge, a very moderate one, for his trouble. And so arbitration became part of his business. Other merchants followed and were, according to Palmer, in fact, trading arbitrators. And it became usual to refer cases of all sorts to arbitration. He then explained that one gentleman who was a court officer named Thomas Loughton, he began to take many, many cases, and ultimately he really did have 50 or 60 arbitration cases referred to him during the time that Mansfield was in office. And Loughton began to charge 3 guineas per case. And according to Palmer, toward the end of the period he was describing, references began to be sent to barristers instead of to other tradespeople. And the barristers then began to charge 3 guineas, not per day, but for each meeting. And so Palmer concludes, this is 1833, so after the parties have been at the expense of preparing for trial, employing counsel, and going into court where they have the court fees to pay, they are often at a heavy charge for an award. Well, that was 1833. How is it today? It's dramatically more. But still, in many contexts, and labor arbitration is one, it's still a comparative bargain economically. Okay, let me go to the second topic, discovery. It hardly needs saying that 21st century litigation is a context in which discovery looms large, both in time and expense. In 18th century England, the rules of practice were dramatically different. And let's return to one of the 2 English cases that were said to have created the rule that private parties could not, by an agreement to arbitrate, oust the courts of jurisdiction, the famous ouster doctrine. And I'll just interrupt my flow here to say, just so that you know this, if you haven't encountered this already, this is from the 1924 House Report on the Federal Arbitration Act, which said, "The need for the law arises from an anachronism of our American law. Some centuries ago, because of the jealousy of the English courts for their own jurisdiction, they refused to enforce specific agreements to arbitrate upon the grounds that the courts were thereby ousted from their jurisdiction. This jealousy survived for so long a period that the principle became firmly embedded in the English common law and was adopted with it to the American courts. And the courts in America have felt the precedent too strongly fixed to be overturned without legislative enactment." And so the Federal Arbitration Act took that place. Well, Wellington against Mackintosh was a case before the Court of Chancery, Lord Chancellor Hardwicke, in 1743. And in earlier work, I've described this case and augmented it with a manuscript report of the case that is not in print, or at least it wasn't before I printed it in the article. and argued that the case really did not, in fact, support the ouster proposition. The plaintiff in Wellington had filed a bill of discovery in Chancery, and in those days you couldn't get discovery from a common law court, but you had to go to Chancery and file a bill in Chancery, and Chancery then would permit that process to go forward in most cases. Hardwick rejected this case that was before him, though, because the defendant said, we shouldn't be here at all because we had an arbitration clause in a partnership agreement that is the subject matter of our dispute. And so it should have gone to arbitration. And Hardwick said he understood the argument, but here I'll just read from the opinion he gave in this manuscript version, which is slightly longer than what's in print from the earlier reports. Hardwick said he would not declare that a plea, that is, an answer from the defendant of this kind, could not be good, but he said if it was good, it would extend as well to the discovery as to the relief prayed for in the bill, for this court will not allow bills of discovery to aid proceedings before arbitrators. Indeed, in the printed report, he puts it a little bit more vividly. He says, because this is part of the plea here, the court would have to admit a discovery in order to assist the arbitrators, which is not proper for the dignity of this court to do. So he said no and discarded the answer and went forward with the litigation instead of sending it off to arbitration. Well, so it was a question of the remedy sought, and what was sought was discovery. Well, at this point, I will ask your indulgence, and I'm going to fast forward across the pond to an 1845 decision by the U.S. Supreme Court by Mr. Justice Joseph Story. And I described this case in some detail in the address that I gave to the National Academy of Arbitrators at the end of my presidential year there in May of 2014. This was a case in which the plaintiff sought judicial enforcement of an arbitration agreement that had allegedly been breached by the defendant, and Story declared, he said, it cannot correctly be said, this is 1845, it cannot correctly be said that the public policy in our age generally favors or encourages arbitrations, which are to be final and conclusive to an extent beyond that which belong to the ordinary operations of the common law. And he claimed that judicial enforcement of arbitration agreements occurred only pursuant to legislation that equipped arbitrators with all of the powers that judges would have, and then the arbitration decisions could always be appealed to the courts. Well, both declarations by Justice Story, I think, with all due deference, were wrong. I think arbitration, and can have demonstrated this in print, was extremely actively practiced throughout the United States at the time. And arbitrators, in fact, had a tradition of encouraging discovery. In Story's commentaries on the law of partnership, he was even more specific. There he said, it's against the policy of the common law and has a tendency to exclude jurisdiction of the Supreme Courts, which are provided by the government with ample means to entertain and decide all legal controversies. And he said specific enforcement in equity of an arbitration clause could not be given, not merely upon the ground of public policy, but also upon the ground of the utter inadequacy of arbitrators to administer entire justice between the parties, from a defect of power in them to examine under oath and to compel the production of papers. So, what should we think about Story's remarks? Hardwick in 1743 said that he saw no reason why parties to arbitration agreements could not include provisions that would give arbitrators powers of interrogation and discovery. And in fact, this is what happened. Many years ago, when I was studying Lord Mansfield in those early days in England and his career over his long run as Chief Justice, I went to the Public Record Office and I called up the King's Bench rule books, the books where a reference would have been recorded, where these orders, these agreements to arbitrate would have been written out by clerks. And the rule books contained lots of orders of the Courts of King's Bench, not just arbitration matters, many things, but two types of arbitration orders were entered there, both the references that have been described to you and the what we'll call submissions to arbitration, the ones that were submitted by affidavit, and these are the John Locke types, where there's no active lawsuit pending, but the parties have agreed to put their agreement into court as if there were a lawsuit pending. And I thumbed through every single page of the rule books for a 32-year period. And these arbitration agreements were extremely interesting. And I was looking at the ones that came out of active litigation that had begun in Mansfield's court. And very quickly, after he became Chief Justice in 1756, new provisions began to appear. And two provisions began to be absolutely regular in the agreements to arbitrate. First was that the witnesses should be sworn. And secondly, relevant documentary evidence should be produced. There were even very specific instructions that sometimes were extended to the arbitrator to, for example, go to the premises if it was a dispute about whether a building had been completed or not. The arbitrator was invited to take a trip, go look at the premises, and of course, that would be extremely helpful. That happens sometimes even today in labor arbitration. We'll say, let's take a time out and go see the location of work where this dispute allegedly took place. So these two features began to be quite standard. Then in London, coming back to the 19th century when Justice Story was making these comments in this country, very shortly after that, in 1849, a treatise was published in London called A Treatise on the Power and Duty of an Arbitrator and the Law of Submissions and Awards. This was a big treatise, 927 pages long. An edition of the same book was published in Philadelphia in the same day, on the same date, 1849. And it's an extraordinary trove of information about the English arbitration practice with full explanations of statutory developments, including a reference to a major statute that was enacted in England in 1833 and 34, the third and fourth year of the reign of King William IV. And this statute expressly authorized arbitrators in references or submissions that had been made a rule of court to administer oaths themselves and to compel production of relevant documentary evidence. Russell described the old practice for swearing witnesses, and this would be before that 1833 statute, but the old practice was, he said, if a case was deciding to be referred, and it was in a jury trial that was happening, what would happen is that the lawyers would write down the names of the witnesses and the name and cause on a piece of paper, give it to the crier of the court, who would then swear the witnesses. And in other cases, if it was a submission, then this would be done with a similar list that would be prepared, and these persons would be brought to the clerk's office or to the judge's chambers and be sworn in, and then they could go be witnesses as sworn witnesses in the arbitration proceedings that took place according to a submission. But that procedure was no longer necessary after the 1833-34 enactment. Okay, next, expertise and complexity. These two often went together, so I'll talk about them simultaneously. I've attached as an appendix to this paper, which can appear in the journal, a compilation of statistics with regard to who the arbitrators were and what their occupations were in these cases that appeared in the rule books. And there are some surprises that are revealed. First, very few men were repeat arbitrators. One person, Thomas Lowton, the one I mentioned before, was unique. He was used frequently. But otherwise, only across this 32 years, only 5 others heard more than 5 cases. 22 arbitrators heard 3 to 5 cases. 73 arbitrators heard 2 cases each. And an amazingly large number, 770 arbitrators heard only a single case. I was quite startled to recognize that fact. Esquires, merchants, and gentlemen were the 3 largest categories of occupations of arbitrators. Now, who fell into those definitional categories, that's not easy to answer. Who was an esquire? That was very loose at the time. Merchants, that was fairly simple to figure out. Who were gentlemen? Gentlemen were the educated gentlemen who spent their days in the coffee houses and who followed the law quite actively, and so were often used as special jurors or as arbitrators. So in addition to specific occupational expertise, that is often reflected in this tabulation. There are many cases that you can identify the subject matter and link it to the occupation of the arbitrator. Obviously, merchants were hearing mercantile cases, commercial cases, but there were a great many carpenters and builders and surveyors who were used as arbitrators in cases that involved issues that they would have specific knowledge about, construction contracts and the like. And in addition to that, some cases were so complex and convoluted that they were considered too difficult for a jury to be able to handle, and instead they were referred to arbitration, often to skilled barristers. Sometimes complicated business suits, even in England in the 18th century, would never even get to a jury because it would go to chancery. These were usually accounting cases where there was a dispute about the monies taken in by a partnership, and one of the partners thought another partner was cheating and would file a suit for an accounting, and that would go to the chancery court, and the chancellor would refer it to one of the masters in chancery, who would then take evidence about this and make a resolution. I'll just mention a 1794 case, which was an interesting case involving a bankruptcy procedure that went to the Court of Chancery, and an accounting was sought. The case was sent to a master in chancery, but to everyone's surprise, the master punted and sent the case to the Court of King's Bench. And he said, you need a verdict of a jury on this state of this long and complicated account. And the case was then presented to Mansfield's successor, Chief Justice Kenyon. This was 1794, and a special jury mostly of merchants. And according to a report of the case in the Times, 2 leading lawyers of the day, barristers of the day, William Garrow, famous for his cross-examination techniques in the Old Bailey, and Thomas Erskine, who was a flamboyant, extraordinary debater in the case law. These were the opposing counsel, and Garrow said, this case consisted of such volumes of paper that he should have no difficulty to say, without danger of being contradicted, that it was absolutely impossible for a court and a jury to decide it. He said if it had originated in a court of law, it would have been considered as one of those causes which from unavoidable necessity must be referred to arbitration. Garrow, so he told Erskine, he said, let's do that. Let's send this case to arbitration. Erskine said he had no objection to refer it, provided they could get some gentleman who must be a young man to devote the rest of his days to the business. And in the end, Garrow and Erskine agreed to refer the case to young barristers, and Kenyon heartily approved. Well, there were brief reports in the Times intermittently of comparable cases. In a case called Handy against Camden, the plaintiff was reported to have said, the counsel for the plaintiff, that he must go through accounts of upwards of £10,000 And he thought everyone should have brought their nightcaps unless they chose to refer the case. And the parties chose to refer the case to Mr. Norris of the Sun Fire Office, insurance office. Another account from the 1791 Summer Assizes docket at Bury St. Edmunds was interesting. The Times included the following paragraph. In a case being presented by a barrister to a special jury, this was an action having to do with the construction of a canal in England between Ipswich and Stowmarket. And after getting a little way into the cause, this is from the Times, and the jury confessing themselves not competent to decide on the skill or merits of canal cutting, nor of the value of the materials, nor of their use or necessity, and not much elucidation being expected from either the bar or the bench on such a subject, the parties agreed to refer the matter in dispute to a gentleman of skill and experience in this branch of the business. Perfectly sensible outcome. And I give a couple of other examples as well. I'll just mention one more. This was before Kenyon in the case of Wilkinson against Wilkinson. This is 1795. Kenyon said, this was a cause of all other, this was a dispute between two brothers who were in the ironworks business. And one of the brothers thought that the other brother had been misbehaving by having destroyed some of their ironworks. And £500,000 allegedly were caught up in this case, which was a lot of money in the day. Kenyon said this was a cause that should have gone to a reference. He said both the plaintiff and defendant were men of character, but he said a cause of this sort was so multifarious that it would be impossible to get to the end of it at jury trial. It was pursuing a shadow, and he was very clear that it ought to go to a reference. It appeared that there were 3 bills in Chancery, each of them several thousand sheets long. So think of that. A bill in Chancery is being handwritten, and each of these 3 bills occupied several thousand sheets of written paper. And he said it would be important for the parties to the case to understand that the Court of Chancery would not settle all these accounts for at least 50 years, so that if it continued in that court, it would descend as a legacy to the executors and administrators of the next generation. And ultimately, by the recommendation of Kenyon, it was agreed all subjects in dispute would be referred to a number of ironmasters who would be selected by the parties. Okay, Kenyon clearly thought that the notion of referring cases to arbitrators for purposes of expertise and for purposes of handling complexity was a good idea on both counts. This was true as well of Kenyon's successor, Lord Ellenborough, so we're well into the 1800s at this stage. All right, I'll come to a conclusion, and then we'll have a very brief postscript. Even in the 18th and 19th centuries, there were, of course, some who were not enthusiastic about arbitration. One of our founding fathers, Daniel Webster, was an outspoken critic. He once wrote in a review that he wrote of a published volume, he said, "No man in this age contends for the illiberal constructions and black-lettered niceties of the ancient gown men," that is, the barristers from the English heritage, "nor will a wise man push to the other extreme and overwhelm all certainty and all rule in the chaos of arbitration principles." Well, in the cases that I've been discussing, and as they demonstrate, I think many of Webster's contemporaries in the English legal community turned to arbitration specifically to avoid the chaos of trying to present and argue complex matters, especially financial ones, to a jury. The arbitration process also provided a way to dodge evidentiary rules that governed the common law courts, and by the evidentiary restrictive rules that I've been referring to, that's the ones where the court would not aid the arbitration process through discovery. And there's another rule that I forgot to mention earlier that I'll just do now that was called the party witness rule. For those of you in law school, you'll be surprised to know about this rule. This was a rule that was true in this country and in England until the late 19th century that said parties to litigation could not testify in court under oath. And isn't that surprising? Why? Why? Well, who more than parties could be considered to be an interested witness? And if you were an interested witness, you were incompetent to testify under oath. And so the parties could not testify under oath. And this had amazing results. One result was that there was a lot of hearsay testimony that was brought into the courts because some witness would come in and says, well, the defendant in this case said the following, but the witness was testifying and the witness was perfectly disinterested. So that was permissible. So it was a very curious and counterproductive rule with regard to the process. Well, and finally, one of the standard provisions that appeared in early Mansfield's time was that began to appear in the arbitration agreements that were included in the rule books was the parties to the case should testify under oath. So both discovery and the ability to testify under oath were incorporated into the arbitration agreements, which would not have been attainable in the standard common law system. Okay, I'm concluding just to say that arbitration today is certainly not the bargain that it once was, yet it remains economically preferable to litigation in many contexts. Also today, the discovery advantage is often its absence rather than its presence, as it was in the early days. But overall, the process, venerable across at least 6 centuries, continues to be of substantial utility as a civilized and peaceable means of final and binding dispute settlement. Now, a postscript. Practicing arbitrators sometimes worry about whether there would ever be a reprisal if they were ever unsafe by having ruled against an employee who was dismissed from employment because the employee was violent, got into fights on the job. Indeed, I once quizzed some arbitrators in the academy about this and got some interesting responses. One very well-known arbitrator said he had to go under police protection for several weeks after he issued an award because he was afraid of what the grievant might do. So I want to share with you a postscript that is some photocopies of documents that I came upon in the Court of King's Bench, and this is from the year 1786. Now, you're not going to be able to read that, I recognize, but I just will tell you what this is. This at the top says, in the King's Bench, and it says, the King against Francis Leng, L-E-N-G. And the next little 3 lines is, interrogatories to be exhibited to Francis Leng, touching and concerning a contempt supposed to have been by him committed against the court of our Lord the King, the King's Bench. And then we have 1, 2, 3, 4 interrogatories that are issued to Francis Leng. And first, and this was the proper grammar of the day, was you or was you not party plaintiff in a certain cause depending in the said court of our Lord the King against one Robert Swales, and which came on to be tried at the Guildhall in the city of London on or about this date in 1786, before the Honorable Francis Buller, one of the justices of King's Bench, and was or was not the said cause and all matters in difference between you and the said defendants then and there referred to the arbitration and determination of John Campbell of London, merchant. That's question one. Second, do you know whether the said John Campbell did or did not proceed to arbitration in accordance with the reference? Third, look upon the paper writing now marked with a capital A. So this is Exhibit A. Did you or did you not write this letter or any part of it? And that carries on. And lastly, if you did not write it, do you know who did? Okay. Next. This is the letter. Now, if you guys, do you have paper copies of this? Oh, good. Well, you can see at the top, you can read the address. It's addressed to John Campbell, Esquire, Charterhouse Square, Aldersgate, London. And then the letter begins at the bottom and carries on. And the last page you have is a translation that I have done of reading this writing. And this writing was written by Lang, the loser in this case, and he's writing to the arbitrator before whom he has just lost a case. And here it's just wonderful. Mr. Campbell, we will not set no name to it, but we are well wiser of Lang. We have all got our wages, and Lang brought the Jane safe home. So this was a dispute about getting wages by seamen who were seamen on board a ship called the Jane. And Mr. Campbell, I have heard him say, Lang, of course Lang is the person who's speaking, but he's pretending that he's somebody else. I have heard him say that she, the Jane, cleared to the owners near £7,000. Campbell, we write this to damn and booger your old eyes for using Lang so. Warn't you a sworn arbitrator to do justice on both sides? We hear that Mr. Swales arbitrated with you. You are a damned old bugger, and to tell thou to take care of thyself. We are Lang's friends and are determined to be revenged on you, except that Lang gets his wages for 5 years and a half. We hear you got most of his wages, £200, it is reported. But damn you, take care of yourself, for we are Mr. Lang's friends, and we will be revenged of you. We will not murder you, but we will break your bones that you may never be able to make another award. So take care, thou old fellow, thou be not safe. We are resolved, when opportunity suits, damn your old eyes for doing so, and may you never be able to make another award nor hold a pen till you repent of what you've done to Mr. Lang, and we will do this, some of us, to you, and may the Pope's curse lie upon you, and may you never die a natural death, but creep about the house like a toad till you repent of what you've done to Mr. Lang. This is from some that does not wish you well, but wishes Mr. Lang well. And then the last sentence he said, the Pope's curse is, may you be taken from the sole of your feet and the crown of your head, and then there's a wax blot, and I couldn't get the rest of it, but he closes with, we will do it. You may depend on it. All right, thank you very much. Takes a while.
So why then the hostility of Justice Story? Given the background in England, why the hostility on this side of the phone?
You know, it's hard to be critical of Justice Story. The man was an absolute phenomenon. He was very old. This was only a few months before his death. when he issued this opinion, and he was speaking ex temp in court, giving his opinion. But I think the answer is simply that Story was a book-learned man, and he issued all of these treatises on partnership and many other subjects, and was a Harvard law professor at the same time. But I don't think he dug into the archives. And so I don't think if you don't look at the archives with regard to what was going on, and as, for instance, those King's Bench rule books, if I hadn't opened those, I would have been substantially ignorant of the practices that I have described. And so I just don't know that Story had his hand in the practice of law sufficiently to let him know what was happening that wasn't evident in print. That's my best guess. That's a good question. Yes.
Just to get this clear, I'm not sure I understand it. Were you saying that a common law party cannot testify?
Under oath. I am saying that.
Under oath.
I am saying that.
And how long did that prevail then?
Until the second half of the 18th century.
Okay, really? That's amazing.
It is amazing,
Yeah.
isn't it? And of course, in the criminal side, in the criminal cases, the criminal defendants weren't allowed to testify under oath anyway, and they didn't even have lawyers. They were not even allowed to have counsel until the end of the 18th century, when by then it had begun to be habitual to allow that on discretionary basis. Criminal defendants could have counsel if a legal question arose during the trial, but not to cross-examine witnesses and not to address the jury, only to argue a legal question that came up. And that didn't change until the 19th century. And who represented the criminal defendants? The answer was the judge. It was the judge's responsibility to look out for the interests of the criminal defendants. And these are the felony cases in the Old Bailey. But in the civil cases, that's where this party witness rule occurred. I once addressed this in some detail in an article that's in the Law and History Review called Truth-Telling in the 18th Century English Courtroom. And if you're interested, you might have a look at that. Yeah, Bob.
Jim, being steeped in arbitration history, has that informed your arbitration practice other than revenge by the grievance?
I don't know that I can give you specific examples where this historical knowledge has infiltrated the conduct of arbitration cases today. My arbitration experience, for those of you who don't know, has been largely in labor arbitration, traditional union management arbitration. I haven't done virtually no non-union cases. So those cases I don't think are linked to this historical past, even though it's interesting.
I have a practice-based question that I might ask.
Yes.
In the talk, you discussed the shifting stance of reasons to arbitrate, and I'm wondering if, as your time as a labor arbitrator, what are some of the key shifts you've seen in the practice of arbitration, or reasons why people are arbitrating certain claims versus others?
Well, of course, my preface is that I've almost entirely done labor arbitration, and so this is always associated with the collective bargaining contract and what kinds of questions and issues arise and what changes have there been. The most substantial flow of cases that come out of that context are discipline and discharge cases when employees have claim that they have been improperly handled by their employer. And I think we've seen some degree of creeping legalism in the process, and certainly more often now than was once the case, both sides will be represented by lawyers in such cases. We've had some new issues that have begun to be recognized that we've talked about at the last two Academy meetings, in fact, having to do with what do we arbitrators do about these statutes that surround us in the world of employment? What do we do about Title VII of the Civil Rights Act? What do we do about non-discrimination clauses that are in collective bargaining contracts which itemize some of the proscriptions of Title VII but not all, or which don't have age discrimination, which was a 1967 enactment instead of 1964, or which don't have disability discrimination? Can we say, and I've actually posed this to fellow members of the Academy when I was riding the circuit, going around talking to the regional meetings of the Academy while I was the president, I said, at one time, I would have said no to the following question. Would it be appropriate for an arbitrator to say, if the action taken by the employer could be shown to be very likely violative of a federal law protection, can we say that that was a dismissal without just cause, even if there's no reference to that statute in the collective bargaining contract? And I would have said that's a step that we should not take. We are the creatures of the contract. Our job is to interpret the contract, and it's not probable, I said, that the parties intended for this protection, the just cause clause, to have been intended to encompass all of this protection out there in federal statutes, the ADA, all of the ones that we are now familiar with. But I don't think that's so radical anymore. I think that some arbitrators are open to that now, especially as we see references to these protected bases of discrimination incorporated into the contract. When I teach a labor arbitration seminar, I sometimes challenge my students this way. I say, imagine that you are representing a union and you're negotiating your first collective bargaining contract. And your job is to draft what you think would be the most beneficial non-discrimination clause for your client, the union. What are you going to say? Are you going to make a list? Are you going to say all of these statutes are incorporated by reference? But if you do that, you run afoul of this wonderful English maxim, inclusio unius, exclusio ulterius. If you include some things in the list by inference, aren't you excluding things that aren't on the list? So that's maybe not a good idea. So what do you just say? You're prohibited from discrimination, period. What does the word discrimination mean? And that's a very hard question to answer, I think. So I have seen that change. And the other thing I was going to mention is that we've been debating in the last couple of Academy meetings what we arbitrators should do about the Americans with Disabilities Act. In particular, applications of that act to conditions that involve mental impairment, a person with a personality disorder or bipolar disorder that acts out in the workplace and is under psychiatric treatment. Is that something we can deal with? Was there just cause for the discipline or discharge because of what was acted out in the workplace? Ordinarily, yes. But there was a reason why it happened. And what's the remedy? What if the remedy is therapeutic treatment for 18 months? Can we tell the employer to hold a job open for 18 months? No, we can't do that. So those are very hard questions, but they're fairly new.
I think we can take one more.
The history of the evolution of the jury through this period is pretty interesting stuff, and the politics of it, both helpers and nullification and all that. Are there any points where that history kind of connects up with the evolution of arbitration that gives some understanding into one side or the other?
Well, I've done a fair amount of work on the history of the jury as well, and it is very interesting. You know, let me say for benefit of this, welcome you students, by the way, from Westminster. Isn't that where you came from? And good for you coming over to this session. But I'll just mention for your benefit, the 7th Amendment to the U.S. Constitution says, in civil suits involving more than $20, the right to trial by jury shall be preserved. Pretty simple, right? But then what right to trial by jury, one asks. And the Supreme Court had to answer that question. And in the early 19th century, the Supreme Court said, well, it can't have meant trial by jury as practiced in the different colonies that became states when we became a republic, because those practices weren't the same in all of the states. So it must have meant trial by jury as practiced in the grand reservoir of our jurisprudence, i.e. England, in 1791, when the Seventh Amendment became effective. And so that became the test. And it is the test to this day. It's called the historical test, and if you claim a right to a trial by jury in a civil case, and the other side says you're not entitled to it, you have to answer the question, would you have been entitled to a jury in a case like this in 1791 in England? That's the test. And doesn't that seem ridiculous? Lots of people have said so. But the problem is the compared to what question. What's a better formula? The Supreme Court has followed this test for years and years. I have argued in print, not very long ago, a position on the following question. What about complex cases? What about cases like I was talking about in this talk, where the English court said a jury just can't handle this? And I have argued that in those situations, there's no constitutional requirement of having a jury for two reasons. One, because in some instances, as we now can demonstrate, in England it would never have been sent to a jury, a case like this in 1791, but would have been sent to arbitration instead. And that was fairly common. And the second reason is that there was another entity that was very important and active across the second half of the 18th century all the way up to the middle of the 19th century, and that was the special jury, a jury for which extra money was paid, where you got experts on the jury who would be able to understand this. Many of the juries, special juries, were juries of merchants. And these juries, you can quote judges' instruction or commentary that are in the newspapers, and I've pulled some of this into articles in the past, where the judge will say, Kenyon, for instance, he will say, this was a marine insurance case. He would say, I have been sitting here for 3 hours without understanding a word. But he said, thank goodness I've got the special jury here, and they will help me understand what's going on. Or he also had the opportunity to have assessors who were retired sea captains come and sit on the bench on either side of him, not as expert witnesses, but as just expert advisors. Would take a break and talk to the assessors, and they would explain why this was or was not a deviation from the insured path that was in the marine insurance policy that covered the issue in question. And in this country, we have eliminated the special jury in federal courts. It's unconstitutional in criminal cases and unlawful according to statute in civil cases. It's still open to states to have special juries. Only one state has legislative authorization that I know of to do this, and that's Delaware. But Delaware has not issued a special jury in a number of years now. So it's fundamentally unavailable, but it's not available. It's unavailable because of our fervent belief in egalitarianism, and we are thinking about this from the perspective of citizens who want to be able to have the opportunity to serve on juries. Now that sounds surprising because most citizens would rather not. If you get a jury, how many of you have served on a jury? I have. You'll have your chance eventually. But if you say, would it be right to deprive you of the right to be on a jury? That's a different question. And you would say, no, that's an invasion of my citizenship. And so we protect the rights of all persons of race, color, creed, etc., to be chosen to be on a jury. And so we can't have juries chosen from lists of people with special qualifications. Now, that's not absolutely true, because the courts have been willing to say that jurors have to have some degree of education and have to be able to read and write and have to be able to speak English. That one's getting contested now in some parts of the country. But it's a long-winded ramble from your question, but the jury was very, very interactive in many kinds of cases, especially commercial cases, insurance cases, and so there would be debate about whether it should be a common jury, whether it should be a special jury, but as I said, quoted that one case, even special juries have their limits, and in one case the special jury had no notion what to do with this canal cutting dispute, so we'll send that to some expert arbitrators. And the use of specialized expertise in the special jury is closely related to sending the case to arbitration. And that was often just a flip of the coin, which one you would do.
Thank you, Professor Olson.
You're welcome. Thanks.